This is Boston Lanka special series on upcoming presidential elections in Sri Lanka. I'm Chitra Aldimir. The 18th Amendment passed on September 8, 2010 has made it possible for the incumbent President Mahinda Rajapaksa to run for the third term. Although Supreme Court has given an opinion in favor of this, Nagananda Kodituwakku, an attorney at law, argues that President Rajapaksa has no legal right to contest the third term. Attorney Kodituwakku, now according to media reports, you have filed a writ application challenging the Election Commissioner's decision to permit the incumbent president to contest for a third term. What is the basis for your writ application?
Application was based. This application, writ application to the court, was based on the basis that Election Commissioner should have rejected the application made by the President Rajapaksa, as he was disqualified to stand for a third term. And also in this application there was another interim relief sought for, that is to suspend the election until such time the writ application was determined. Why? It was an interesting question, why it was filed. And the Constitution, as you know, after the second term, he was elected to the office for the second term, and there was an amendment brought in, that is 18th Amendment, and that particular amendment was, by this amendment, and the restriction placed for this for the office of the president only for the two terms was removed. Basically, it read as follows: no person who has been twice elected to the office of the president by the people shall be qualified thereafter to be elected to such office by the people. This was the provision as it stands prior to the amendment was brought in. And this is what was removed with the 18th Amendment. However, this amended provision was with prospective effect. There is no the provision in the amended law that it would apply with retrospective effect. That is the very reason this application was made to court. Why? Because the interpretation of statute law, section 6.3, it says, whenever any written law repealed either whole or part, a former written law, such repeal shall not, in the absence of any express provision to that effect, affect or deem to be have affected. So that is how the interpretation of statute law, set out in a situation like this. Since there was no express provision in the amended law, whatever the amendment brought in by the 18th Amendment, it has no retrospective effect. Therefore, President Rajapaksa was disqualified for a third term. And if you study the constitutional history of this country, there was an amendment, that is Amendment 2 of the Constitution, to the 1978 Amendment. And there was very clearly a provision, I think it is Section 3 of that particular, Section 3 of that the second amendment to the 1978 Constitution. There was a provision to apply the particular amendment with retrospective effect. So therefore, that there was no issue about the application of that particular amendment to anything done prior to that amendment came into force. However, when this issue was discussed in public, the government, what they did, they referred the president, he referred this issue to the Supreme Court. Who is holding the office of the Chief Justice in this country today? That is Mr. Mohan Peris. Now the issue arises, whether Mr. Mohan Piris can entertain this kind of a question, or whether he is occupying the office of the Chief Justice lawfully. The argument put forward by the petitioner in this case is that he accepted the office of the Chief Justice when there was no vacancy. In the first place, I think it was on the 1st of January 2013, and the removal of the Chief Justice was challenged in the Supreme Court. And the determination of the Supreme Court was that the whole process adopted by the Parliamentary Select Committee was void, invalid. And later on, the same issue was challenged before the Court of Appeal. That is on 7th January 2013. And the Court of Appeal quashed the entire findings of the Parliamentary Select Committee. So therefore, there was no vacancy when Mr. Mohan Piris made a statement under oath on 15th January 2013, taking the appointment to the office of the Chief Justice. Basically, the statement Mr. Mohan Piris made under oath amounts to a false statement when there was no vacancy. He knew that very well. There was no vacancy in the office. Therefore, it was amount to a false oath. False statement made under, any statement that was false was amount to a false statement, and therefore the petitioner believed that he should have been charged for perjury. Unfortunately, as the whole country is fully aware, there is no rule of law in this country. There is no rule of good governance in this country. Executive is holding a very, very firm grip on the entire judiciary. So therefore, basically the petitioner argued the basis of this application is that whatever the decision made by Mr. Mohan Piris, acceptance of the two questions referred by the head of the state, it was who did it? That is Mr. Mohan Piris. Who decided not to award a fair hearing, public hearing? That was Mr. Mohan Piris. Therefore, any decision taken by Mr. Mohan Piris, sitting as the Chief Justice, is invalid in law. That is the very basis this application was put before the Supreme Court.
I think I have to ask this question. Why you keep referring Chief Justice Mohan Piris as not legally appointed Chief Justice?
More than anybody else, Mr. Mohan Piris is fully well aware. He is very well aware. He is holding the office of the Chief Justice unlawfully. Right? Therefore, in the event somebody wanted to remove him from the office of the Chief Justice, there need not be any impeachment process to be followed, because there is a Chief Justice in this country, and on the other, I think you are aware of it. After he assumed the office of the Chief Justice, he appointed a 5-judge bench, and that is basically to ratify his appointment. That is to overrule the two decisions already pronounced by the Court of Appeal and the Supreme Court. So that itself, who appointed the bench that was appointed by Mr. Mohan Piris. And therefore, he is not entitled to get his appointment ratified by a bench appointed by himself. Therefore, this appointment made unlawfully continues. That is the stand taken by the petitioner in this case.
But as you know, the Supreme Court has held that President Rajapaksa can contest for a third term.
Yeah. I understand. That is now a lot of people are under the impression the issue is now settled. There's an opinion expressed by the Supreme Court. I understand, because now they don't take this issue out of the box. They are discussing it within the box, inside the box. If you come out of the box, if you discuss the matter, open it up, you will realize how come whatever the decision made by the Supreme Court, right? It is basically the whole issue was entertained by Mr. Mohan. He was the chief legal advisor to the president. He occupied of the chief justice, and he who probably advised the President Rajapaksa to not to take up oath as the president after he was elected to the office of the president for the second term. He who probably drafted this 18th Amendment can the same person. Now then the president appointed him his own legal advisor to the office of the Chief Justice unlawfully. I stress the word unlawfully because there was no vacancy. So therefore, although people think that there's a decision made by the Supreme Court, there is no such decision, lawful decision made by the Supreme Court, because the person who entertained these two questions is appointed to the office of the Chief Justice unlawfully. He made a statement under oath which was false. He knew more than anybody else it was a false statement. Therefore, acceptance of the two questions, denial of the public hearing, all that is done by one individual who is holding the office of the Chief Justice unlawfully. Therefore, the opinion expressed by it is, with due respect to the Supreme Court, I must say, opinion expressed by the Supreme Court is not worth the paper it's written on.
Attorney Kodituwakku, do you claim that the integrity of the judiciary has been lost?
Exactly. With this appointment, there are so many. I am one of such lawyers. We have, in writing, informed the Supreme Court, informed the judiciary that we will not practice under the current setup. And I have, in fact, brought this to the notice of the Bar Association and also to the Commonwealth Office, that I have opted not to practice law in this country until such time the rule of law and the integrity in the judiciary is restored. It is completely lost under the current regime. Take for example the writ court of this country. Writ court is the court where you make writ applications against the government agencies. Recently, President Rajapaksa appointed 2 judges to the writ court from the Attorney General Department. These 2 officials, they are public officials. They represented and defended the respondents in the very same court. How come the citizens of this country can expect justice expect fair hearing and fair trial before these officers? Once they are appointed to the judiciary, how come the citizens of this country can expect a fair hearing? I can give a classic example. Recently, I represented a client before the writ court, before these 2 judges. And the rule book very clearly states, when application is filed before court and the respondent notice is issued with to the respondents, the Attorney General shall file statement of objection within 28 days. That is what the rule book says. Because of the preferential treatment given to the Attorney General by the very same officials, judges appointed to the Court of Appeal and the Supreme Court from the Attorney General Department, it's natural because they work there and their own colleagues, their very same colleagues, appearing before them, when they make an application, they tend to consider it. In this particular case, maybe after 7 months or so, maybe 6th or 7th consecutive times, the court allowed Attorney General further time again and again. Despite the fact petitioners taken a very strong objection, it was disregarded. Finally, I had to make a statement in court that my client has completely lost the confidence in the judiciary, and therefore I had to, in the interest of the client, withdraw because I cannot tolerate this. Because there are certain lawyers who are not willing to compromise the integrity under whatever the circumstances may be. So therefore, that's what I say. So people in this, it is very sad situation. So this is the fundamental error made by the President Rajapaksa. But he shouldn't have, bring the entire, now you know that earlier the Attorney General Department functioned independently. Today, it is function under the President Rajapaksa, which is not, that is not acceptable at all. Role of the Attorney General is to uphold the rule of law. What is happening today? He will do anything what the President wants. When he asks, withdraw the indictment issued on such and such a day, against such and such a person, and against such and such a person, Attorney General, what he does, immediately appear before this High Court and withdraw the indictment. Is that the thing that you expect from the Attorney General? No. And when there's now, you saw that very recently there was at the Colombo, Fort Railway Station, some individual citizen was attacked by police. Right? I think you can recollect a similar incident happened in London, that G20 protest. Some Tom Kenlington or somebody who was attacked by police, Metropolitan Police, a similar incident. What happened? BBC covered the whole thing and it was telecast and the people saw the whole incident. And the very serious charge was brought against the Metropolitan Police. Undisclosed amount of compensation was awarded against the police, Metropolitan Police, and they had to make a public apology. Whereas in Sri Lanka, that person, the whole country saw the whole incident. When this incident was brought up before the Supreme Court by way of a fundamental right application, what happened? Application was dismissed. This is the kind of judiciary we have. I don't know exactly under what circumstances it was dismissed, but the whole country is fully aware it was a pure abuse of, excessive, power, abuse of power by the police.
Now I understand that your motion for the writ application was scheduled to be taken up yesterday.
When this application was initially filed on 16th of December, that is very much prior to the court vacation was resumed. And petitioner gave 3 days, that is 17th, 18th and 19th to support this application. What happened after that? Suddenly, the petition filed in court, duly acknowledged by the registrar with a receipt issued and duly recorded, disappeared. And in this application, it is very important to mention, petitioner very clearly asked the court to appoint 2 judges to hear this application, appointed to the Supreme Court, to the Court of Appeal, not from the Attorney General Department. So, when this the writ application filed before court was disappeared, what happened? And after that, there was no way that this application can be, taken up before 2 independent judges, because now the court's vacation resumed. Then the petition was asked. A further motion was filed by the petitioner with another set of documents, but it was very clearly mentioned in the motion book that he was filing a further copy, whereas the registrar recorded that the original petition had not been filed by the petitioner, which is a completely false and unfounded statement. How come? When the second petition was, when a fresh set of documents filed before court, it was fixed for support on 2nd of January, that is today. Again, the petitioner asked in the motion filed in court that the independent 2 judges, not from the Attorney General Department, should be, appointed to the Court of Appeal, should be appointed to hear this case. It was not done. And how come this petitioner can expect justice from when he very clearly expressed his, inform the court that the two judges from the, not the two judges already occupying the writ court should hear this application is not taken into consideration. So now today the matter was taken up before the very same judges, right, who were appointed to the court from the Aegis department. So it's for that simple reason. The petitioner had no other option but to withdraw the application. That is the kind of judiciary we have.